Good day, everybody. I'm Attorney Madrel Shea B. De Guzman. I am your lecturer for Criminal Law Book 1. Our topic for today is Article 5 of the Revised Penal Code, which discusses the duty of the court in connection with acts which should be repressed but which are not covered by the law and in cases of excessive punishment. Remember that on our very first video for Criminal Law Book 1, yung general principles in criminal law, we have discussed the principle of nullum crimen nullum pena sine lege. Nullum crimen nullum pena sine lege. Okay. Which roughly translates to there's no crime if there's no law punishing it. There's no crime if there's no law punishing it. That principle is also the basis of Article 5 of the Revised Penal Code. Ang ibig sabihin, this article covers the scenario wherein there is no law which punishes specific acts, no matter how criminal it may seem. If there's no law that punishes such act, and then the duty of the court is to acquit the person for performing such acts because they are not crimes. Okay, they are not considered crimes. But the court has the duty to report the same to the chief executive. Okay, so yung korte, i-report niya sa chief executive that a law should be passed in order to make those acts criminal. Naalala nyo yung example ko noon, yung kay Katrina Halili, okay, during the Haydenco fiasco. Okay, what was filed by Katrina Halili was for RA 9262 for emotional abuse, claiming that she suffered emotional anxiety, moral anxiety because of the distribution of the sex videos with Haydenco. Okay, at that time, there's still no anti-video voyeurism law, meaning the act of recording sexual acts without the consent of the parties involved in the video is not criminal. So at that time, wala pang krimen. So there's no law punishing it at that time. Therefore, Haydenco cannot be prosecuted for such crimes. Okay. Yun yung isa sa mga situations na kino-cover nitong Article 5. Dapat i-acquit ng korte, okay, yung akusado kasi wala namang batas. Okay. Otherwise, it will result to judicial legislation. Okay. Ang mga korte, wala naman silang kakayahan or authority, okay, para mag-impose, okay, or para gumawa ng batas. What the court does is for it to interpret the laws, and the persons who are who have the obligation to make and enact the laws is the Congress. Okay, Congress ang gumagawa ng batas, ini-interpret lang nila, ini-implement ng executive. So wala silang authority para baguhin ang batas or mag-impose ng penalty kung wala namang batas na nag-i-impose ng penalty. That is the first scenario. There's no crime if there's no law punishing it. The second scenario is if a particular law provides for excessive punishment, okay, which is not commensurate to the acts performed. Okay, merong isang case, I think, wherein the court modified, okay, the penalty imposed upon a convict. This is the case of Vaca versus Court of Appeals, if I'm not mistaken. This is a BP22 case. Okay, the penalty which should have been imposed is imprisonment, but because the court considered the old age, okay, and the lack of propensity on the part of the convict, of the accused, to perform the acts or to perform the crime, okay, the court just imposed, okay, the penalty of fine. Okay, yun yung sa BP22. However, if you're going to read Article 5 of the Revised Penal Code, the duty of the court is to submit to the chief executive through the Department of Justice its recommendation, okay, a statement or a report, okay, that the penalty is excessive, okay, without suspending the execution of the sentence. So dapat nga, sabi ko, the court should just interpret or interpret the laws, okay, which has already been enacted.